stage when couple of things will happen. This process starts with the administering oath to the witnesses, not in all jurisdictions, but in some of the jurisdictions. In country like India and UK, under our respective acts, in fact, in of UK, their arbitration act is also of 96. They have provision which authorizes an arbitrator to administer oath. And in India, under Oaths Act, arbitrators are empowered to administer oath. So we are in the same boat of oath is concerned. Are in fact in international arbitration, they are persons and therefore make a statement that they will make truthful statement. So my there was some problem with my internet, so you will have to bear with me, though my technical guy is working on this. I can't hear you now. Probably you can hear me. Hope I am now audible and if all is fine with everybody. If anybody can say yes. Oh, it said, yeah, Brijesh said yes. Okay, great. Now let me move ahead. So this hearing, which is starting now, after all of this had happened, prior to this hearing, a lot of exercise is done by the presiding arbitrator or the arbitrator for management of the pre-hearing conferences and meetings take place, and a lot of instructions are issued for making arrangements for the oral hearing and the hearing or the trial, whatever you call it. So this, and thereafter there is a process called opening a statement, then happens cross-examination. After opening a statement, actually thereafter happens administration oath, and the witness acknowledges his witness statement. Thereafter cross-examination takes place. Thereafter re-examination if necessary. Thereafter post hearing, post cross-examination, you will after the process of post hearing brief deliberation and award is passed. So today we will talk about hearing, and this is very arbitrator as a lawyer all have to take very collaborative approach to ensure that the hearing goes smooth, uninterrupted, and all preparations done properly. Please appreciate for hearings all the stakeholders, arbitrators, if you have 3-panel arbitration, then all the 3 arbitrators, all the lawyers, all the parties, all the witnesses from all across the globe will assemble for the hearing and therefore all arrangements are to be made. A lot of housekeeping exercise needs to be undertaken, and it is to be taken with all seriousness. Now I'll try to give a picture in everybody's mind about how hearing takes place, so that sitting here you can sense how hearing would take place and how hearing takes place in any properly run arbitration or any proper international arbitration hearing. First of all, first thing, so far as arrangement is concerned, first thing one has to ensure that proper hearing room is arranged for, and for this responsibility sometimes is given to one of the parties, subject to the apportionment of the cost as per the orders of the tribunal. Tribunal has to also take active interest in ensuring that all the arrangements are properly done. In fact, there are lots of experienced arbitrators who will visit the hearing room a day before the hearing. Vidhatri says my voice is breaking. I have some internet issue, it seems. I'm trying to be as loud as I can, and राजीव को बोलो देखेगा क्या चक्कर. Now so, but what happens is there are some hearing facilities and rooms in different part of world which are proper for any proper hearing. So if hearing arrangements are made in those centers and facilities, then one can be assured of proper arrangements. I can give you my personal experience of visiting and being with some of the best arbitration hearing facilities in world. ICSID, that is headquartered in World Bank, headquarters at Washington DC. I have visited that place. I had lunch with their Secretary General way back in 2014. And in fact, we observed one international investment arbitration hearing as well. They have got huge rooms and rooms of different sizes with all facilities, video conferencing, separate screens for display of exhibits and PowerPoints, proper arrangements for mic, proper arrangement, chairs, arrangements for keeping the executive director had invited me for lunch. It was set up by 12 top law firms of New York. So NIAC does not administer arbitration, but it only provides facilities for arbitration. This is very good center from the perspective of facilities. SEAC administers arbitration. It's arbitrations in Maxwell Chambers in Singapore. I have been there. London Court of International Arbitration has very good hearing rooms. At Fleet Street in London, I have done hearings there as well. In fact, in India, ICA has a couple of hearing rooms which are appropriate, not all. ICADR in Vasant Kunj in Delhi has some hearing rooms for domestic arbitration, I would say. In fact, it is like a courtroom. So once I was chairing one arbitration there, sitting in the ICADR hearing room. It is on a very high pedestal. It's very high where arbitrators sit. So I could feel that I am sitting in courtroom as a presiding judge. MCIA in Mumbai has hearing facilities. In fact, they have got one breakout room as well. I have done arbitrations in MCIA hearing facilities as arbitrator. So so it is very important. Please appreciate arbitration hearings goes on for days. Obviously, I'm going to tell you that thumb rule is 7 days plus minus, depending on the complexity of the case. Now, it is very important, therefore, that you have proper arrangements in place. Chairs are to be comfortable. In fact, in Delhi, uh, lots of arbitrations takes place in five-star hotels. And some of the hotels, I should not name because they'll get discredited. I stopped doing my arbitrations in those centers because they provide chairs which are without arms. Now you cannot sit for a whole day without arm, without proper arrangement, without a proper sitting arrangement. Now, therefore, it is important that proper sitting arrangements are made. Video conferencing facility wherever, in whatever, in wherever it is needed, so that facility should be available. So all good centers will have these hearing facility, the video conferencing facilities, and whenever you need it, you can use them. In fact, you need to have uh, at least one screen where you can show your points. Sometimes, like in one arbitration in London, I had shown a video to the tribunal. Now, for all of this, you need to have such arrangement already available. During the course of cross-examination, you may be referring to some documents and you want to show them the tribunal on the screen. That is again very important. Now, another thing I would say, proper food arrangement. One may laugh at it, but it is equally important. You can't sit for a week without proper food. And now this is the room. This is the hearing room. Now, in every good hearing facility and center, only hearing room is not enough. You need breakout rooms. What are these breakout rooms? You need at least 3 breakout rooms. Breakout rooms are those rooms which are made available to the parties and to the arbitrators for their internal meetings and conversations. Now, during lunchtime, you break for lunch, and thereafter, if you get time, you sit and discuss amongst yourself. So lawyers can sit together and discuss. They can sit with the witnesses. Obviously, once cross-examination starts, that witness cannot sit, but others. So you need to have proper breakout rooms. So breakout rooms where both sides, lawyers and parties, can discuss in private. And similarly, you need to have breakout room for arbitrators, where arbitrators can privately deliberate amongst themselves. So you should not be only contented with the hearing room, but you also need breakout rooms. Now in India, we do not have such facilities in any center. MCIA has one room which is called arbitrators lounge. But then if you have other arbitrators sitting in that, then obviously arbitrators cannot deliberate. So what happens in Indian setup is, whenever one party wants to have some private discussion, wants to have some instruction, so they will go out of the hearing room and then they will discuss. but they cannot carry all their files, they cannot have proper meeting. Similarly, if tribunal wants to deliberate amongst themselves, then they'll ask both sides and everybody to leave the room. So it is bit cumbersome, and it is not appropriate, I would say, going by the international standards. Now, so this was about the rooms. Now let us talk about how is the layout in the hearing room. What is the layout in the hearing room? So when you enter in the hearing room, what you get to see and what you should see, generally what should be layout, see that the table should be U-shaped. U-shaped table is the proper arrangement. In boardroom style arrangement, but it should not be complete circular table or egg shaped table. It should be U-shaped table, and I'll tell you why. On both sides, on the arms of the U, parties will sit on both sides. So one side will sit on one side, another side will sit on another side. Which side, which party should sit is again a convention in international arbitration. I am going to share with you in a minute. So it should be U-shaped. On the arm of this U, both sides, both parties, lawyers will sit. And at the end, 3 arbitrators will sit. This is the layout. This is not the complete layout though. Now, when you enter the room from the gate, now on both sides lawyers have sat. So, and it is you, and one end the arbitrators have sat. In the middle of the room, you will have a table and 2 chairs. That is meant for witness. So that witness is not sitting with the lawyers or both sides. He is sitting in front of the tribunal. He is facing the tribunal, and tribunal is facing the witness. And I also talked about one more chair besides the chair of the witness. That chair sometimes is used by translator. So if that witness speaks different language than the language of the proceeding, then you need to have a translator. So you must have an arrangement for that, and it is all should be well thought before hearing takes place, so that proper instructions are passed. Though good centers will always have such systems in place. And now where claimant, lawyers and claimants will sit, and where tribunal will sit, members will sit. So I said at the end of the U, on one side, tribunal members will sit. Now, I will not tell you now which side of the chairman nominee, which nominee arbitrator will sit. Before that, I'll tell you that on the left hand side of the chairperson, claimant's team should sit as per the convention, not written convention but unwritten convention. So on the left hand side of the chairperson, the claimant's team will sit. So obviously on other side, on the right side of the chairman, respondent side will sit. Now I have to tell you where those nominee arbitrators, co-arbitrators will sit. The claimant's nominee arbitrator will not sit on the left of the chairman, because on his left is again the claimant side. So he will sit on the right side of the chairperson. And then obviously on the left side of the chairperson will sit the respondents nominee arbitrators. So this is the sitting arrangement. In your hearing room, there will be mic for everybody. There will be laptop for everybody. Now, we had discussed about simultaneous transcription in the arbitration, which is like a must for every international arbitration. So generally, the transcribers, they are generally 2 in numbers, not less than 2. They will sit in the corner of the room, one corner of the room, closer to the chairperson and preferably on the left hand side, depending on the space. But generally what I get to see is on the left hand side corner. So they'll have their own table, their own chairs where they put their machine. So this is the typical sitting arrangement, typical layout of the chairperson, but not immediately before the eye, but on somewhere after, behind the witness at some height. So these are typical layouts. Now, let us talk about lawyers and everybody. One should be very clear in mind that it is a very serious proceeding, serious most stage of the arbitration. Everybody should be formally dressed. Formally dressed does not mean that you wear your national dress and go there and wear that. It should be formal dress, formal business dress. So suit and tie and stuff like this. Now, another important caution for everybody is reach the venue at least 20 minutes before the hearing starts. Reach the venue, I am repeating it, reach the venue at least 20 minutes before the hearing starts. It serves multiple purposes. First, you get comfortable. You have come from your hotel or wherever. So you are at ease with yourself. You are not stressed. Witnesses are making themselves comfortable. And you go and put your files at appropriate place. Put your notes at appropriate place. All thing. And particularly on the first day, you are supposed to, once you enter the room, it is the right practice to extend courtesy to everybody, greet everybody, greet the arbitrators, greet the other side lawyers and everybody sits. Give your visiting card even to the transcribers, because so that they know who are you, because they have to, while writing the transcription, when you speak, they will write before they write what you are speaking. They write your name, so and so, Mr. So and so. So they should know who are you. Now, in the hearing room, only authorized persons are supposed to sit. So before hearing itself, all these correspondences take place, that who are the people who are coming to attend the hearing, what is their description. So all of this is already in everybody's notice. Then another important aspect is sequestration. Sequestration, 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 Tration. Sequestration is a process through which some tribunals will ask other witnesses to leave the room. Suppose witness A has to depose first, then other witnesses will be asked to leave the room. And you know, this is also common in India in court setup also. And logic behind this sequestration is that other witnesses should not get wiser with the testimony of the witness who is deposing. Now, sequestration, I have seen, is a personal choice. In some arbitration, parties agree with each other, tribunal agrees with everybody that we will not go with. In some, it is insisted upon, and if it is so, then you have to follow this. So that was about sequestration. However, there is a catch in sequestration. I was doing one arbitration in London. It was LCIA building. Now in that, one gentleman who was witness was sitting with me, and he was asked to leave the room. Now, to this, my answer was, though he is a witness and theoretically he should have gone out when others are testifying. However, he is the party representative who instructs me as a counsel in this case. So if he leaves, it will become a handicap for me, and therefore he should not be asked to leave. And what I said was not something which I devised for the first time. This is again an accepted norm. Those witnesses, those persons who are otherwise witnesses but are also the instructing party from the party side, they should not be asked to leave the room, because here you have to balance between two competing aspects. One aspect, I told you the logic behind sequestration, but at the same time, another balancing factor you have to keep this in mind is sequestration. Somebody is saying, what is the definition of sequestration? I told you, sequestration is a process in which non-testifying witnesses are asked to leave the hearing room so that they do not listen to the cross-examination of other witness. I hope now it is clear to everybody. Now again, I come back to this. So there are competing aspects whether the instructing person should be asked to leave the room. If he is asked to leave the room, it is an issue of proper representation on my part before the tribunal. And this is always given more weightage than the requirement of sequestration. I hope I'm clear. There are 5 witnesses from my side. One person is deposing, but ideally 4 would have left from my side. But I said, not 4, only 3 should go out. And one should be allowed to remain with me because he gives me, instructs me whenever I need any factual input. So I must have a client with me who should give me factual input. So this request was accepted. Now this is the sequestration. So you entered the room, you took your chair, everybody sat at the places designated, you exchanged the visiting card. Now what happens? Now what will happen is that the moment you sit, chairperson will welcome everybody, and thereafter other co-arbitrators will also greet everybody. So everybody exchange the pleasantries. Now I had said earlier also that how should we address the tribunal? We should address the tribunal by saying, Mr. Chairman, sir, Mr. Co-arbitrator, sir, Mr. So-and-so, and the Honorable Tribunal. These are the expressions generally used. In India, it is slightly different. It is different because in other parts of world, invariably arbitrators are lawyers or technical persons. I'm not saying that in other countries retired judges do not sit as arbitrator, but most of them are barristers, so lawyers. But in India, most of the arbitrators we have are honorable judges who retired from various courts. And if you have been addressing a particular judge in court by my lords, obviously you will do so even in arbitration. And this is the tradition in our Indian arbitration setup. And we give them same respect and due respect by addressing them as my lords. Some may tell you don't address us as my lords. If that is the instruction, then you should note. But that is the case. Now, after this has happened, that you know how to address the chairman and the tribunal, I said generally hearings are for 7 days as a thumb rule, because you must know what all has to take place. Opening statement has to take place, examination in chief has to take place, cross examination has to take place, and closing statement has to take place. Till now what had happened was written advocacy, an exchange of written submissions only. So therefore, I am giving you a thumb rule of 7 days. It may be lesser than that as per the requirement of the case, as per the nature of the hearing, as per the stage of the hearing, and as per complexity of the hearing. Now you would also like to know how many hours these sittings will go. Effective hearing time is 6 hours a day. And how many hours one side lawyer gets, again formula is 1 hour per half day, one side. So you have 2 half days. So one lawyer gets 2 hours. So 2 hours goes to one side of the lawyers, 2 hours goes to another side of lawyers. So it makes 4 hours. Then you may wonder what will happen to the remaining 2 hours. Those 2 hours are kept by the arbitrators for their questioning, their instructions, dictation of orders, some unexpected situations may arise that needs to be dealt with. So 2 hours is kept by them. Sometimes these 2 hours are not consumed by the tribunal, then that unconsumed, non-consumed time is called float time. People who are the construction professionals, engineers, I know some of the gentlemen who are participating in this. Mr. Dilip Pudduke is a retired chief engineer. He sits as arbitrator. And in fact, one judgment which I am going to ask everybody to read on the challenge to award and public policy, SsangYong judgment, he was the arbitrator who had written the dissenting award, minority award, and his award has been upheld by the Supreme Court. And Supreme Court for the first time broke all these earlier precedents and accepted his final award and said this becomes the award. Otherwise, once award is set aside, parties are asked to go and reinitiate the arbitration. Aside the award, we accept the minority award, because minority award is not an award in that sense, because majority award too had agreed with the majority. In this case, for the first time, Supreme Court, Justice Nariman had written this judgment. This award, his award was accepted. Now he would understand float. So when we talk about programming, delay analysis for construction disputes and construction arbitration, Mr. Srivastava, who is a retired ex-CMD of NHPC, now Mr. A.B. Srivastava, he sits as arbitrator. He has done many construction arbitrations and projects. He would know what I am saying about float. Mr. Subhas Patel, he's another arbitrator. He was the chief engineer. He was secretary of a particular government, state of Gujarat. He was member of NHAI. He sits as arbitrator. He again knows what I am saying. So all engineers would know float, what float means. But here, float only means the left out time, which is again the same thing in the construction industry. So whatever time is not consumed by the arbitrator out of the balance 2 hours will be allocated to the two parties and sometimes to the needing party. Arbitrators will not just tell you that I will have, because whether arbitrators are left with float or not, that you get to know only at the end, towards the end, not at the end, towards the end, when we are approaching the end or afternoon. And by then tribunal gets to see what is the pace of the cross-examination or the oral submissions. So that is, in fact, even in the construction industry, for construction arbitration, one of the issues typically arises between the parties is who owns the float. So I am taking that analogy here as well. Now, one thing I would again insist, if there are more than 2 parties in arbitration, how R6 are divided? See, in a particular day, see, ultimately this division has its genesis in how many hours are available to the tribunal. If you have 2, then you, but again, it is not necessary that this division of time will go in this manner for all the purposes on every day, because I'm going to come out with another theory and probably this will answer that query and take care of other queries as well. Now, before I move ahead to Vibhuti says, what is the name of the judgment? SsangYong, SsangYong. It was international arbitration. SsangYong. Now, Before I move ahead to the other aspects of the hearing and high hearing room, I must caution everybody that be polite to the tribunal, be polite to the other side lawyer. And if I say be polite to the tribunal, why I say so? Because there is a famous saying in arbitration world that arbitrators are human beings. Now in first blush one may think, what rubbish, arbitrators are human beings. But what I am trying to tell you is, arbitrators are human beings means you have to treat them well. You should try to take them on the right side. You should be the hand holder for the arbitrator. You should generate enough confidence in the arbitration tribunal. You should be honest. You should behave in, you should do advocacy in the hearing in good faith. In fact, there is a lot of literature on good faith advocacy in arbitration. And if you follow all these basic norms, then you will find arbitrators looking at you whenever they are in any, they need any clarification, they are under any confusion, they need any hand holding, and this goes a long way. Sometimes in a hearing, in fact, there are a lot of psychological paper written, lot of papers written by psychologists about how it happens in any typically in arbitration, that arbitrators will start looking at one side. What are the psychological reasons for that? And if that happens, you should think that you have done a better advocacy than the other side. It is very, very important. Now, now we come to this. So everybody sat, everybody exchanged the pleasantries, chairman welcomed everybody. Now what happens thereafter? Thereafter, typically in international arbitration, there is a process called opening statement, which we do not see in Indian courts, which we do not see in Indian arbitration. Arbitrations happening in India, unless it is international arbitration. There are some high courts. In fact, Delhi High Court also had its rules and guidelines. There are indications for that, opening a statement, but it never happens. Nobody follows that. But in international arbitration, and I would say that generally, and in basically in US English, a style of arbitration, and which is really dominated and procedure of opening a statement. So what happens is, the moment tribunal assembles, the tribunal will say, do we need any opening statement? Now, what is opening a statement to start with? Opening a statement is the oral statement by the lawyer, oral argument by the lawyer, and it starts with the claimant lawyer, in which claimant lawyer is going to tell, basically is going to lay out the framework of what all is going to happen during, what he is going to do and what he is going to achieve through his witnesses. I'll repeat myself at least 2 times because it is a bit complex. Through opening a statement, lawyer of the claimant, to start with, is going to tell the tribunal that I am citing today 4 witnesses. through the witness testimony, which has already come on record through witness statements, which will be tested through cross examination, I am going to demonstrate before this tribunal A, B, C, D. So it is a concise statement. Thumb rule, you take it 30 minutes each side. So there is no arguments as such on legal aspects. Basically, through the opening statement, lawyer is going to say what he is going to prove through his witnesses during this hearing. This is the opening statement. So claimant's lawyer will come out with, again, you as a lawyer, if you are appearing as a lawyer, you have to also think and decide. So this is again a tactical thing which both lawyers have to think. There is one school of thought which I support, that this is the advantage, first time you are getting this advantage to speak through your mouth for the first time before the tribunal. Arvind Rathore says, I am not audible. Am I audible? If yes, please say yes. Oh, I am audible then. Okay, thank you very much. So I was talking about opening a statement. In this opening statement, Sumit Kansal says, Sumit, witness statement is already on record. Witness statement is already on record. So that witness statement has come. Now, through all the witness statements, what is that you are going to prove and establish before the tribunal? So what is that you are going to produce before the tribunal is the relevant aspect. You may decide to not go out with opening a statement. You may decide to go ahead with opening a statement. If you ask me, I'll say, if you are confident enough, and apart from witness statement, apart from evidentiary document, in fact, in open witness statement, sometimes lawyers also use video. Suppose your allegation is, your case is that the respondent supplied me a defective machine. It vibrates, it does not run smoothly. If you ask me, I will tell you the first thing you should do, that you should run a video so that it gives the visual imprint in the mind of the tribunal. It becomes visible. A lot of efforts can be saved through video, through the witness statement and testimony. So I'll use that out of 30 minutes, I'll use 10 minutes for my video. And video should be, again, all parts properly nomenclature, so that at the bottom of the video you should have some still video, combination of the two. So this is an opportunity which can be used to your great advantage. You should know this, but you have to take a decision depending on the nature and strength of your case. So this is the opening statement. Now, after this, the witness who is being cited as the first witness for which request has come to be cited as first witness, he will be asked to sit on the witness, in the witness stand. He will be asked to come to the witness stand. There we call it witness stand, though it is a chair. And he will be, if oath is being administered, then he may be asked to take oath. Sometimes they will be asked to take oath in the name of God. You have people, they are atheists, so they may refuse to take oath through that process. So, but they may be asked to make the statement of truth. Now, after this, Apurva says, what should be covered in the video? Brief facts of the case. No, never go. See, if you have to show some contractual provision or something like this, or brief fact, that is all written in your document. These are exhibits. Video, I said, suppose building a dam, a power plant, suppose the chimney is tilted. You take a picture so that it is tilted. Machine is having problem, so run the machine, take the video. You can show them the vibration and everything. So these are the tactical decisions one has to take, which you acquire with experience. Now comes the stage where witness has sat, he has been administered oath. Then what happens is, before the witness, on the witness stand, on the stand, on the table where witness is sitting, one bundle of file, all exhibits, all is kept, which will contain his witness testimony also. One question may be asked, can he carry any personal note or some diary? He can carry. But if you have very shrewd other side lawyer, he can object to this. In that event, tribunal show to the tribunal what is that document, what is that paper which he is carrying. If it is his personal notes, tribunal will not object to it, he can use it. But if it is some important document, quote unquote document, which could have otherwise been used as exhibit or evidence, if it has got this kind of nature, and which has, in that case, tribunal may ask that gentleman to also produce that document to make it a part of record. Now he can obviously have this, his witness statement. Now claimant's counsel now will show to the, now this is the time he has set, this is the time for the hearing, for the tribunal and for the lawyer to make him acknowledge his own testimony, that is the witness statement. So lawyer will ask him, Mr. So and so, please see this exhibit or see page number so and so of your bundle. Is it your witness statement? He will say yes, if it is his witness statement. Then lawyer will again ask him, does that witness statement at the last page, which is page number so and so, bears your signature? He will say yes. So all of this is now being recorded. In fact, everything is being recorded from the beginning, when tribunal chairman started welcoming everybody sitting in the room. From that moment onwards, yes, it is like chief examination. Yes. So from that moment, when chairman greeted everybody, transcribers have started writing everything, and every single word uttered by you, uttered by other side, uttered by witness, uttered by arbitrator, uttered by co-arbitrator, anybody saying anything will get translated at the speed anybody is speaking, that will come on your screen. In fact, even somebody said something jokingly, even that will come. That is why whenever you have simultaneous transcription, there is highest degree of discipline, because it makes the whole process very formal. And these transcriptions are used by the parties while challenging the award. And this is the best proof of what all transpired. In fact, whenever any the arbitrator is challenged on the ground of bias, even then these transcriptions are used. Suppose a particular arbitrator during the course of hearing unreasonably and unnecessarily or unreasonably, or these expressions are not proper, if he favors one side demonstrably, which is obviously wrong, so obviously how he does that? He says something. He says something to the co-arbitrator. He says something to the lawyer. He says something to the witness. So all is getting recorded, and this can be used against that arbitrator. So that everybody should keep this in mind, that every single word is recorded. In fact, there are very, very rare situations where a tribunal may say off the record. Generally, tribunal, the strict chairmen and generally chairmen will not have anything off the record. But in some circumstances, you can have something off the record. Suppose a witness has, during the course of cross-examination, fallen sick. I have had occasion where I was cross-examining a witness. He was trying to be over smart, and I had to be tough with him with my questions. And he said, "Now I'm not feeling well, I'll fall down and all." So what happens? In such situations, if you have such situation occurring in your hearing, you should, tribunal will say that since it is a personal issue, we will have this off the record. So there are some situations where tribunal can have off the record. Now, everything is being recorded. Now what is happening is, the person, the witness has acknowledged his witness testimony, sorry, witness statement, and now process of cross-examination starts. And this process of cross-examination is the most crucial aspect of the hearing. Not opening a statement, not closing a statement. In India, our understanding in India is that this trial hearings or hearing means that is essentially is a process where people get to see lawyerism, people get to hear the arguments, and that is the most important aspect. But that is not the case. As I said in my initial talk, that in international arbitration, you have to assume that all arbitrators have gone through the file, they know the facts, they know every aspect of the matter. So it is not that you have to educate the tribunal with the facts of the case for the first time. It is not that stage. So therefore, what gets prominence in these hearings is cross-examination. In many cases, even closing statement is dispensed with. There is no closing statement. After cross-examination, nothing. Only thing would be that tribunal will ask the parties to file post hearing briefs, which we in India call written arguments or written synopsis. So this cross examination is very important aspect. It can ruin the case of a party. It can make the case of a party. It needs to be taken with all seriousness. Tribunal takes with all seriousness. Tribunal members will take notes, and how to take notes is another art, but that will take a lot of time for me to really explain that. So I'll not go into how tribunal members should take note. That in itself will become one day session. So I don't want to go into that, but they take notes. They look at the demeanor of the witness. They look at the body language of the witness. They are at complete attention. They are in complete attention. Please appreciate, you're talking about big matters. Quite a lot is at stake. At stake is parties' reputation, parties' money. At the same time is at stake tribunal members' own reputation, their credibility, how you conduct the proceeding as chairman or co-arbitrator. That is being observed by the parties' lawyer. Tomorrow they will say, yes, this gentleman is the fantastic arbitrator. Please appreciate there are a lot of arbitration centers, including HKIC, which asks the parties and parties' lawyers to give a feedback form about their experience in the arbitration hearing, about the facility, about the conduct, about the nature of the arbitrators, the way they conduct, about everything. So you have to prove yourself as an arbitrator as well, and you have to also prove yourself as a lawyer, because you are being watched by potential case reference. So everybody takes this with all seriousness, and with this cross examination starts. And now I have 15 minutes. So I'll try to cover a bit of this, because tomorrow would be the last day. So I have to cover a couple of aspects. So I'm very comfortable with the time. So tomorrow we can surely cover this as well. Now, what is the objective of the cross examination? I'm going into that aspect. In fact, generally what happens is, before I go about the objective, let me talk about one thing. What happens when one of the parties is asking for cross examination, other side is objecting to it? What should arbitrator do? This is a common question. Answer to this is, tribunal has no option but to, under Indian setup, under Indian law, tribunal has no option but to allow cross examination. Internationally, it depends on the rules and the mandatory law of that particular jurisdiction. But there are cases in international arbitration where tribunal members have denied cross examination. But again, it is a serious decision, because it is a due process issue, where one party may go to court after award is passed that I was not given proper opportunity to present my case by putting questions and testing the veracity and other things and as well. So one should err, if at all you have to err, one should err on the side of allowing cross examination. And so far as Indian arbitration is concerned, India seated arbitration is concerned, tribunal members have no option but to allow cross examination. Now, what is the purpose and objective of cross examination? Lot of people does arbitrate cross examination, but unmindful of the objective behind the cross examination. Objective behind the cross examination, if I start by saying, is demolish the case of the other side through the mouth of their witness, and prove your case through the mouth of the other side's witness. to establish before the tribunal that testimony of that particular witness is not credit worthy. That is the fundamental thing. And why I am saying so? Someone may say, everybody knows you go to demolish. If you keep this in mind that I have to demolish their case through the mouth of their witness and I have to prove my case through the mouth of the other side's witness, then you will keep these two things in your mind during entire process of cross-examination. Cross-examination, there is a debate whether it is an art or science. I say it is in some sense it is science, in some sense it is art. Somebody said, how can one teach cross-examination? I said, obviously you have to deliberate upon this. We have to learn from each other. Cross-examination, first principle for learning cross-examination is know all the theoretical aspects of the cross-examination. If you do not know all the theoretical aspects of cross-examination, which I'll try to cover today and tomorrow, then you will invariably, what we get to see in India is most of the people are not aware of the theoretical aspects, jurisprudential aspect of cross-examination, but they do cross-examination, they are doing cross-examination. That is not appropriate. You are not justifying your brief. First, you know the theory, then practices. And for this, again, there is something which we need to discuss. And I'll tell you, cross-examination, teaching of cross-examination. How can I teach you cross-examination? Let me tell you one thing, give you an analogy. Can I teach you how to cycle? Can I teach you somebody how to cycle? I can teach a person cycling is a process in which you jump and sit on a seat of the cycle, hold the handle and paddle it. Obviously, I'm talking about that cycle, old age cycle, without third and fourth wheels on the side of the rear tire wheel. No. Bicycle means bicycle. I can tell you, jump on the seat, sit on the seat, hold the handle, start pedaling it. I told you this. Now, can you go jump on the cycle, hold the handle and start pedaling? Will it run? It will run, but you will fall. You may fall, you may get up, you may fall, you may get up. And ultimately, you will learn the art of cross-examination. So, ladies and gentlemen, you start with the theoretical learning. Then you start observing seniors and others while doing cross-examination. When they do that cross-examination, you will not be able to learn cross-examination by observing unless you have gone through the file for which that cross-examination is happening. Unless you have for yourself prepared questions in your mind, even if somebody, I'm talking about young lawyers and law students. Suppose in your chamber, your senior is going to cross-examining the case. You go through the file. You are not going to cross-examine, but you go through the file. Prepare questions yourself for your own benefit. Prepare your own note. Assuming that you are going to cross-examine the witness, though you are not going to cross-examine the witness. Then go and observe your senior doing cross-examination. Then only you will get to learn. Unless you have mastered the fact and the law, nobody can cross-examine. Similarly, you as an associate will not be able to master the cross examination and learn the cross examination until unless you know all the intricacies of the case. So when you have gone through everything, then you are observing your senior, then you get to know why he is asking a question, why he is not asking a question on something, where he is stopping himself, how much he is asking, the way he is asking, is he repeating himself? Obviously, I'm going to touch upon, I'll give you all the tips, necessary tips, how to do cross examination, how to raise objections during the cross examinations, which are sustainable. So I'm going to discuss all of this tomorrow, and I'll also talk about difference between civil law and common law culture, and how cross examination goes different in these two cultures, though I had touched upon this as well. Now my daughter is nodding, she says it is 6:54. Okay beta, so 6:54 and we have 6 minutes. So I'll take all the questions which you have for today's talk, and we'll meet tomorrow. And tomorrow we will go for cross examination, all the tips, all the techniques, art. We will have challenges to the award, correction to the award, and we'll end by talking about how to break into arbitration world and what accreditation are going to help you. So these are going to be the tomorrow's talk. So today's talk I'm going to end, and I'll take questions if you have any. Somebody says, can foreign award be enforced in India if it is against public policy of India? Any foreign award which is against public policy of India will not be enforced. In fact, latest judgment, you have NEFED judgment also, which recognizes, New York Convention says so. Award, if it is a foreign award, it must conform with the requirement of the definition and scope of public policy of the country where award is sought to be enforced. So if award passed in Singapore has been to India, but that award is not conforming with the public policy of India, then that award will not be enforced. Yes. Witness can be recalled if some important points are left. Is there any provision? See, as I said, international arbitration, there is no provision. So this question itself has some problem. There is no provision. It all depends on the tribunal. If tribunal, it is a rarity. Recalling of witness is not at all a common thing to happen. In very rare case, it can be done. You have provision for re-examination that I'm going to touch. Yes. What is legal misconduct of an arbitrator? Legal misconduct, first of all, this legal misconduct was a very popular phrase in India under 1940 Arbitration Act. After that, it has disappeared from the scene. This is not a ground for challenge in award of award. Legal misconduct means ethical things and something which is unbecoming of an arbitrator. That is legal misconduct. You may refer to NEFED judgment by SC. I said NEFED judgment. Attended PSU arbitration, but no room facilities. Are the rules and facilities not standard in India? Vital aspect of drafting prayer in pleading. I have talked about pleadings. Now I'll talk about awards tomorrow. Vivek Gupta, thank you everyone. Can expert opinion be taken without the orders of the tribunal? This is one thing I'm going to talk tomorrow. Experts are routinely used in complex matters by the parties. Tribunal will be well advised to not refuse any party from citing expert witnesses, because it will constitute violation of due process, violation of right to present its case. So you cannot deny a party his right to present its case. So therefore it should not be denied. IBA guidelines also recognizes this particular aspect. Tribunal wants to appoint, tribunal will appoint, but if party wants to appoint, party should be allowed to appoint. What are kinds of arbitration agreement? I am sorry, Kajal, we have already dealt in great detail arbitration agreement. I cannot repeat myself now. So you can message me independently, we'll deal with this. Could you share the draft of pleadings? If possible, I'll try to talk to the organizers. It would be helpful if you could discuss about international arbitration award recognition enforcement. I'll talk about this tomorrow. Somebody had asked me to discuss my personal journey. I forget his name in the very beginning. I don't know whether it is important, but if it is important for anybody, let me just say in few words. I did masters in geology before I did my law, and I am the only qualified geologist. Obviously, I did immediately after graduation, and I did the masters in geology, and I'm only qualified lawyer in India who is geologist who does mining matters. I do a lot of mining arbitrations as well. And after I did law, that was 95, and then draft for Arbitration Act 1996 was being circulated. I found it very interesting as a subject, and that time what was happening was I found that this act is going to be substantially different from 1940 Act. So if I start following this act from very beginning, it will be helpful, and I'll be rather learning with the whole process. And in fact, this you can take some clue from here. Young lawyers and the law students, now you have 2015 Act which has substantially changed, 2019 amendment. So you can take it that way. And thereafter, though, when I worked with my senior, who was one of the finest civil lawyer, commercial lawyer in Delhi High Court, became thereafter. I worked with him, observed court proceedings, observed a lot of hearings. However, he did not have arbitration work. So whatever I know about arbitration is my all personal endeavor. And immediately after I left my chamber of my senior in 2000, so I was there basically with him for 4.5 years. And thereafter I started my practice. And my first assignment was for an arbitration, big arbitration before one retired Chief Justice of India. And there I was engaged by a senior advocate. He knew my civil law and trial capabilities, whatever I was doing. He was impressed with my hard work. So he engaged me for prepare him for cross-examination and other things and helping him in the case. This is how I started the journey. Thereafter, cases started coming one after another. I started pursuing this. So I was doing civil matters, commercial matters, as well as arbitration matters. Thereafter, I started sitting as arbitrator matters, and I got associated. I became director of Chartered Institute of Arbitrators UK. 12 years back, I became founder chairman of Society of Construction Law India. I became governing body member, executive member of many arbitration institutions. I became fellow. I have got fellowship from 5-6 topmost international organizations. So every one thing started leading to another, and that is my journey. And with this, it is 7:02, and we close today's talk, and we'll meet tomorrow. Thank you, everybody. Thank you. Thank you.
Thank you, everyone. Thank you, Ratan sir, for the session. A request to everyone that since there was some technical difficulty on Facebook, so we weren't able to go live on Facebook, what we made the live session on YouTube. So for tomorrow's session, we will be going live on YouTube again. And those who are attending live session on YouTube, please come on YouTube and enter the session. Thank you very much. Thank you, everyone. Thank you, sir.
Thank you. Regular Facebook Live.